Right. Good afternoon to everyone who's joined us for day two. And this is the English stream. Welcome to the Data Protection Africa Summit 2020 virtual. And as we did say yesterday, virtual is here to stay. COVID or not, we will make some progress and make great strides towards achieving a deeper understanding of privacy issues and advancing the cause of data rights on the continent. The Data Protection Africa Summit is organized by the Africa Digital Rights Hub. And yesterday we had a pretty good day, and we're going to start today with another regulators progress dialogue. And helping us do that is the fearless leader of the Data Protection Commission of Mauritius. Since 2007, Judicia Maddob has been the Data Protection Commissioner of Mauritius. She's passionate about her work and very much in love with what she does. She's cultivated an inner steady source of motivation, which constantly drives her to do her best. And she's a lawyer by profession, holds an LLB from the University of Mauritius, and she's also a Chevening scholar who earned an LLM in international rights at Essex University in Colchester, United Kingdom. So I welcome you all, and I welcome you, Judicia. I hope it's still sunny in Mauritius.
Yes, indeed. It's very, very sunny. Actually, we are around 38 degrees Celsius. So you can guess how hot it is. And for a Friday, it's very bright outside and it's almost 5:30. So just the perfect weather to be in. Thank you so much, Mr. Adu. I'm very happy and glad to be joining this session today and for the nice introduction as well. So I would just go straight away in my presentation. I guess you will be sharing the screen for me. So if you could just start with the first slide of my presentation, and that would be a very nice way of just starting it. Thank you.
Okay, wonderful. So just a quick context while that's being done. I know that the law did change. Initially, you had a law which was repealed and replaced by the 2017 Act. Would you be able to share with us what went into the change? What needed to be amended to make the law more progressive?
Okay, so basically, let me give you, a brief history about data protection in Mauritius, so that you would understand better why we shifted to this new legislative framework. We had our first legislation in 2004. Actually, it was dormant up to 2009 when it came into force. But I actually started the office in 2007, where I was called to really make sure to, operationalize the office. And the law, I was the one who actually made the operational provisions come into force in 2009. And we started the office in 2009. From there on, there was some very nice principles in our Data Protection Act of 2004, which followed the previous GDPR EU directive of 1995. But there are also some basic considerations belonging to the national context, which were inserted in the legislation. So it was a beautiful mix. I mean, to have the very first piece of legislation on data protection, it was quite a very good starting point. So what we did, then we realized when I started the office, and I realized that we need to move quite fast in terms of making the principles more lively, making things more concrete and up to date. So we started working with the Council of Europe, Convention 108. We signed the convention, the first convention, and now we have ratified also Convention 108 plus. As you know, also we are the first African country who has ratified already this convention and we're awaiting its entry into force. So in 2017, finally, after many years, our efforts came to fruit, and we passed the second legislation, that is the Data Protection Act of 2017, which came into force on the 15th of January 2018. And that was a landslide because it actually incorporates all the relevant principles from the GDPR in the immersion context, and we made a law adaptive to our, to our situation. So we had to really ensure that the GDPR provisions, not only like it's a copy paste, it's not a copy paste, but it's a very innovative piece of legislation which brings in only those provisions from the GDPR which make sense in our context. But basically, most of them did, and you would see that there are many similarities between the GDPR and the DPA, but we also have our own provisions which makes it unique in its way. So that was on 15th of January 2018. That is some months before the GDPR actually came into force itself. That was the 25th of May 2018, as you know. So in that way, we became really a pioneer in making this legislation. Sorry, I was looking at the slide. We can move to the first slide in the meantime, the second slide, sorry. So in that way, this legislation actually inspired a lot from the GDPR. And we wanted also to make sure that our constitution, can we move to the second slide, please? Is that possible? Second slide, please. Hello? Hello, I'm not, sorry, excuse me.
Okay, it's being worked on, so you can carry on.
Okay, because I'm not, the slides are not moving. Okay, so yeah, so sorry, I didn't get it because my slides are not moving right now.
Yeah, it's not moving yet, so you can okay, yeah, we're there now, so you can take over.
Okay. Okay, thank you. Sorry, I just wanted to know whether I go by the slides or you will put the questions to me and I will answer them.
No, I think you should go through the slides and then we'll ask some questions after the presentation.
Great, that's nice. That's why what I wanted to do. It would be very much concrete. Thank you so much.
Wonderful.
Okay,
right, so over to
yeah, I will just say next slide and then you move on to each and every slide. Thank you. So as you can see here on the slide is actually we have in our constitution itself in sections 3 and 9 of the constitution a constitutional right to privacy. And it's very important, I think, that our constitution basically has this type of fundamental human right provision, which brings the importance of in our context. And we also have another provision in which is Article 22 of our Mauritian Civil Code, and which talks about le respect de la vie privée in French, which means that is you have to respect the privacy rights of people. So already here, before the Data Protection Act actually came into force, and we already had these two provisions here, and they were already existent in our legislative framework. So it's very important to understand that we have such a history that we have always, in a way, protected the fundamental human right to privacy of people for many, many years, even before the DPA of 2004. This is how privacy started in Mauritius. So I was saying, now we move on to the next slide. We have the Data Protection Act now. Next slide, please. Yes, we have this now, the Data Protection Act of 2017. As I said, it came into force on the 15th of January 2018. And the main aim behind this legislation is to actually modernize all the provisions on my functions, the powers of the office, the enforcement and the application of the legislation. And I think it's working, because it's really a modern set of provisions. Next slide, please. Yes. So as I told you, we wanted to align our legislation with international standards, the EU GDPR, and also the Convention 108 that we acceded to in June 2016. So this is our main motivation here and the rationale behind the Data Protection Act of 2017. Next slide, please. Next slide, please. Yes. What are actually the benefits that we have seen the new Data Protection Act is bringing to the people here, to public and private sector both alike, is that we are being able to attract more foreign investment because we have such a set of principles which is making it easier for people to actually invest in Mauritius, not only from Europe, but from the US and from other parts of the country, even from Africa. And this is actually bringing a lot of benefits to our economy. And also, most importantly, the ease of doing business in Mauritius. This is a concept that we put a lot of emphasis in here in Mauritius, and we try to ensure that all the legislative frameworks that we have, including the DPA, actually go in that direction of the ease of doing business. And not the least is allowing, the digital economy to flourish by putting individuals in control of their own data and reinforcing legal and practical certainty for economic operators and public and private sector as well. So our main consideration and concern was actually really to protect the people's human rights to privacy by putting them in control of their data, which is also a shared, you would see, concept in the GDPR. So, but there are also other obligations for better data management for businesses and new rights that have been given to people to access information, etc. And also now we see, because we have been working a lot with companies and organizations in Mauritius, they have actually realized the importance of having a data protection culture in their organization. Just yesterday, I did a webinar for the Audit Committee Forum here in Mauritius, which is affiliated with the ACCA and KPMG as well. And they developed, along with the office, a set of guidelines, on data protection regarding businesses in Mauritius. And this is a document that they are going to serve for their consultancy and whenever they are going to attract new clients to promote the data protection culture in Mauritius. This is just one example. There are so many, but just yesterday we have launched that guide that were produced by the DPO, the Data Protection Office, KPMG, ACCA, and the Audit Committee Forum. Next slide, please. Definitely a success for this year, ratification of this protocol Convention 108 Plus. And as you know, as I said, since 1st of October 2017, Mauritius has been a party to Convention 108. Now in 2020, we are actually the first African country. Next slide, please. Next slide. Yes, on 4th of September 2020, we have ratified the Convention 108 Plus, and we became the 6th state to actually to ratify this convention. I see someone saying that the slides are blurred. I don't know if we can actually correct that problem. Edu? Yeah, can we move on? Yes.
Yeah, the slides are fine from where I am. It's clear on my screen.
Okay, I just saw that remark here on my screen. Okay, so let's move on now to the next slide, EU adequacy. EU adequacy. Next slide, please. Yes, so now we have our second mission for next year. We have already embarked on it, is actually negotiating. We are actually in negotiation with the EU adequacy with the EU for EU adequacy of Mauritius. And we are selecting an expert consultant to be able to carry out a complete independent assessment of our data protection law in Mauritius. And we are just awaiting this to be finalized for us to actually implement this. All right, next slide, please. So some of the achievements that I just wanted to highlight here is what we've done for this year is what we made a major conference in January, on 28th of January this year, and which actually attracted some international people as well, and around 550 participants, where we explained the interaction between the Data Protection Act and the GDPR. And it was quite a huge success for the Data Protection Office, because we also produced a guide. Next slide, please. We also produced a guide where we explain the Data Protection Act. This is another guide, but we have also produced a guide on Data Protection Act itself. So what are the provisions of the Data Protection Act, how it's going to impact the industry, and what are the rights. Everything is in that guide, and it's a very comprehensive piece that we have put on the market for people to be able to use. Another guide that we have published for this year is the guide on data protection and the media, is because we realize that there are many media implications, data protection implications with the media that even in Mauritius we've been facing many infringements, and we thought it was the right time to do it. We have published this, and the Media Council has actually promoted it, and I think that was a very important guide as well. Let's go on to the next slide. We have produced, next slide, we have produced a training toolkit, and this is like a 7-hour CD video on data protection, any aspect of the Data Protection Act in Mauritius. And if you want to have a look at it, you see the link here. I would seriously advise you to go and have a look at it, because it's very, very, very innovative in the sense that it gives you a self training that you can actually do. You can just use that CD within your organization, and you train your staff on the important elements of data protection. But we did it for the Data Protection Act of Mauritius, but there are many principles that we have explained in detail on this. So please go ahead, have a look at it. It's on our website. I think you will enjoy it. Next slide, please. We have also produced for this year, during the COVID situation, the guide on data protection for health data and AI solutions. And this actually, we had to do it to make sure that, the health authorities and any of the private sector dealing with COVID data, COVID health data or privacy personal data, are actually protecting special categories of information, that is sensitive data, that are involved, and they are not, abusing on AI and other mobile applications. So we made this guide to be able to assist, and it has also been very, very widely used and effectively appreciated, because we have put it in the context, and it's really, really practical. And next slide, please. Next slide, please. So this one, we have just produced it. It's a guide on national security and privacy in Mauritius, but we explain all the principles, international principles. This guide, we have done it because Mauritius is now a smart country. There is smart cameras everywhere in the country. We have produced also a code of practice for the Mauritius Police Force, which is actually binding on them for them to implement data protection standards whilst operating smart cameras in the country. There is a set of laws that have been enacted to ensure that protection of privacy is being done in the right way. So we made a guide on national security and privacy in Mauritius, to ensure, that these principles are actually being implemented in the proper fashion, coupled with a code of practice for the Mauritius Police Force as well. But this guide is actually broader than the code of practice, and it explains on all aspects of privacy and national security. Next slide, please. Next slide, please. Yes, and we have just finalized this one, information sheet on privacy and virtual currency. Again, we all related to the context, but it's general in nature and can be used as well. On virtual currency, why? Because there's so many, e-money now that are being used everywhere in Mauritius, and we wanted to ensure that privacy is also being protected, and we produced this guide as well. Next slide, please. Next slide, please. Yes. So as you know, why we are doing all this, because, AI applications now as part of the COVID-19 pandemic, challenge is being used to really promote certain health issues. So we are very careful because I won't be able to go into the details of all of them. We have produced a set of laws as well on COVID, where privacy considerations have been implemented in these laws. And we are not neglecting privacy in no way in these legislative framework, even during times of emergency. So this is how far for this year. I would say thanks. And to conclude, I would conclude my presentation here, unless you have other questions, and I would be very glad to answer to all of them. Sorry for the hiccups in between. It's just because of the slides, movement. Okay. Thank you.
Thank you very much, Aditya. So I'm going to do something slightly different. I'm going to invite questions from our audience. You could use the Q&A button and type your questions, and we'll fill the questions to Aditya to give you answers. But yes, there's a couple of things that I would like to start off with. So under the law, which is your Act of 2017, you have some exemptions. Can you explain to us what the types of processing that are exempted and why those were chosen?
Okay, so what we have, first of all, we have exceptions. As you know, if you don't have the consent of the person, you have other exceptions that you can use. You don't need consent in all scenarios. And this is actually in line with all GDPR principles as well. We need to have exceptions like, let's say, public interest, legitimate interests of controllers, vital interests of a data subject, contractual provisions, legal obligations. All these exceptions, we need them to be able to process data otherwise, because we know how difficult it can be in certain circumstances to get the consent of individuals in all scenarios. So this is the first exceptions that we have in the law, and they are in line with all principles around the world. But we also have some certain exemptions, general exemptions, which are also to be found in the GDPR relating to national security, other legal obligations of the country, public safety. All these are the general types of exemptions, like you will find in any constitutional provision, for example. And these are the exemptions that we have, and they are all, I guess, in line with principles. So they have not in any way distorted, the data protection application.
Okay, so we've got a few. Great. We've got a few questions coming in. I think it's Ariani Omeri has a question. Has your office carried out any enforcement actions on behalf of Mauritian data subjects against international organizations that have experienced personal data breaches?
Oh, yes. Well, all our investigations are confidential in nature. We don't disclose this is part of our law. It's confidential in nature. But I must tell you that we have cooperated with UK to a certain extent on the Cambridge Analytica scandal, we were actually concerned with Mauritian citizens' data, and we did certain inquiries for, and Facebook as well. We have been working on certain issues where actually, because we don't have a Facebook headquarters in Mauritius, and we cannot actually sue them in Mauritius, but we were so concerned with our citizens' data that we wrote to Facebook, and we've been liaising with them very, very on a regular basis to find certain solutions. And I must say, up to now, we have been quite successful in these implementations, and it's working along with other authorities in Mauritius, police cybercrime, CERT-MU as well, who are targeting cyber incidents. So we work together because we are found under the same ministry, and we cooperate. We try to bring solutions to these international challenges. But we have done many enforcement, yes.
Okay, another question from Adadik Kantamaklo says, I'm curious, what aspects of the GDPR are not applicable in Mauritius? I'm assuming that data protection issues must be standard across the world.
Right. As you know, the GDPR is extraterritorial, and if it involves EU citizens' data, even if it's in Mauritius, it will still be applicable. That's from a GDPR perspective. But for us, Mauritius, I mean, those provisions that are not relevant to us are actually the EU-centric provisions in the GDPR, which are not relevant to our context and which we cannot in any way use. These are the provisions that have not been reproduced in the Mauritian DPA. Otherwise, the other provisions, whether it has not been incorporated in the DPA, doesn't really matter, because GDPR is applicable outside the boundaries of EU, of Europe, which means that if they want to go to sue someone because EU's data is involved and is in Mauritius, they can actually do it. So that's why we're moving for EU adequacy of the Data Protection Act, because once we have the Data Protection Act of Mauritius recognized as adequate with the EU, it means that all the provisions of the DPA will be applicable in the GDPR context, which means that not necessarily the GDPR provisions which will be applicable, but the DPA provisions of Mauritius which will be applicable. So you understand, it's a very important step to go to, because it protects our data, the Mauritian people, Mauritian population, because also what we have
Okay, I'm suspecting that we have a slight challenge with the internet connection, but once we're able to re-establish connection, we should field some of the questions that are coming through. And I know you can still keep your questions coming through via the Q&A button. Just type your questions in there, and we'll be able to have Judicia answer them. Wonderful, we have you back.
Okay, great. I just lost you. I'm sorry. So what I was saying is that the GDPR provisions leads to administrative fines. So the difference is, if we are recognized as adequate, then we can prosecute through the DPA, and the GDPR does not have to actually do another action against our people again. So it's like a double, So this is why we are avoiding this particular, double surplus age, I must put it this way, between the GDPR and the DPA, leading to many complexities and confusion. And we want to avoid this in the future. So this is our project with EU adequacy.
Wonderful. Now, another question is making reference to the fact that you mentioned Facebook in your statement earlier, that you couldn't sue Facebook because they're not headquartered in Mauritius. However, they operate in Mauritius over the internet. Does that mean organizations with no headquarters can breach data and literally walk away, or are there alternatives?
No, not at all. This is how it's very important. Your question is very, very important, because what we did is because the headquarters is based in Ireland, for example. So we contacted the Ireland and the ICO UK Commissioner's Office Data Protection, and we started working with them from their end so that they could actually relay the problem to the Facebook headquarters there. So this is where, you know, cooperation between data protection authorities really, in terms of enforcement, becomes really, really something which is not to be you know, looked at as if it's not happening. It is happening very well, and we cooperate many, like, you know, probably you've seen joint investigations amongst EU countries on an issue. This has also happened in our context for Facebook, and if ever we need to do it for Google or Microsoft, we have headquarters here. Google, we don't. So if we need to really do all these activities, there is a way out. There is a solution to it. And one of our functions in our data protection act says we need to internationally cooperate with other supervisory authorities. It's part of our duties as well to do it. So it's not something that we just do. It's part of our law as well.
Okay. And another question from an attendee who didn't provide a name said, kindly give us an insight into how AI can breach one's data rights. And secondly, what punitive measures are in place in Mauritian law against perpetrators who use AI to...
Absolutely.
Yeah.
Yes. So we have the same provision like in the GDPR. You might be aware of this, the right not to be subject to automated individual decision making. That is, we have a specific right in the Data Protection Act which says no one is to be subject to a machine decision. So this is what is the right not to be subject to automated individual decision making, and this is in our law. So AI actually forms part of that scenario, and no one is actually subject to this type of machinery without the consent of the person. But there are certain exceptions also in that section where actually you can do it, but in a proper way. That is, it's being monitored by our office, and we're being able to see what's happening de visu about AI solutions. So you see, there's a good protection here in the Data Protection Act on AI and other machine operated solutions.
Okay. Now, Michael Mudd sends one in. It's actually not a question, but he says he's really looking forward to the new guide on national security and privacy. And thumbs up to you. Very forward looking, he says.
It's already here. It's already here. Yes. It's already available on the website. Yes.
On the website. Okay. All right. Yes. So, Michael, you can pick that up on the Mauritian website. So, last week, the UK's ICO made public its enforcement actions against British Airways and Marriott. Isn't transparency in this regard important?
Yes. So how, you know, for us, because it's very complicated, our legislation requires prosecution, which is not the case for the UK. They don't prosecute. We prosecute. We recommend prosecution, actually. We don't start prosecution straight away. Let me explain. We start by doing an inquiry, and then we recommend prosecution if we think that there is prosecution. And then if we recommend prosecution, the person has the right to appeal against our decision to the what we call the Information and Communication Technologies Tribunal here. So then if a tribunal decides that we are right, actually then it becomes public. And that's why our inquiries are confidential, and it's protecting the rights of the people involved. It's confidential because we cannot disclose this inquiry up to the time that we decide to go for prosecution, which is the next step. It's not the first step in our inquiry. So that's why we keep it confidential. And if the person does not appeal to the tribunal, then we solicit the Director of Public Prosecutions to go ahead with prosecution. So we actually buffer up this particular enforcement, making it more protective for the person because it's criminal in nature. Whereas for UK, it's not criminal in nature. Transparency is a must for them. You understand the difference between our contexts. Ours is criminal in nature, so our enquiries are confidential, as is any other police inquiry is also confidential for us as well. It's confidential up to the time that we finalize and send the report for prosecution, and the director of public prosecutions decides to prosecute, then it becomes within the realm of justice. So this is how it works here in Mauritius.
Okay. So in Tamak, Serge, I would like to know, where do you see the debate about harmonization of data protection laws across Africa going, including the AU Convention as well, and also adequacy options with the European Union?
Right. You will realize that this is the most sensitive question that we are actually facing in the data protection world. Harmonization. Well, let us be very practical. Harmonization to an extent is possible, but harmonization in its entirety will never be possible. What we need to actually achieve is a working, a piece of set of principles that we work with them, we implement them, and it doesn't affect our structure. So this is what we have to look at. Let's see, for example, the AU Convention on Cybersecurity and Data Protection. As you know, this convention, the Malabo Convention, was inspired a little bit from Convention 108, right? Some other provisions, and maybe some from the EU directive as well, which was the precursor of 1995, not the GDPR. So already we are talking about the old laws, old international standards that the Malabo Convention itself inspired it from. Now the world has evolved a little bit. We have a GDPR, we have Convention 108 plus, which are different in their perspectives. So basically, we are here with a set of principles which is being challenged a little bit because it's following old principles. And I'm not saying all of them are not relevant. I'm not saying that they cannot be used, they cannot be implemented. Of course they can be. But then, as you see, how the world is evolving so fast in data protection, are we gearing ourselves towards these principles? Also, it's very important to highlight that we don't need always to ensure that our African context is, as I said, a copy-paste situation of a European context or the Asia-Pacific context or any other context. We don't need to do that. But we definitely need to take principles that are here and make them work in our context. We don't have to invent. What we need to do is we take this principle and see whether it matches our context, it matches our purposes, and then we go forward with them. So this is how we did here in Mauritius with the Data Protection Act. So even in the African context, now, if we need to, let's say, how do you say that? We need to just bring some changes to the AU Convention or to bring some other elements, a resolution or guidelines as they're doing at the level of a UN, why not? Why we don't have to restrict ourselves with only a convention? We can have guidelines at the level of proper enforcement done. Why we say that? Because the people who come to register with the information that they provide us, we already have a very good view of what actually they do, what is their business, what are they doing. Instead, we would have to go and inspect each and every organization dealing with data to know actually how they are handling data. Whereas here, we are being provided with a set, I must say, of information which helps us in enforcement. So this is why we maintain our registration here. And I really militated for having less, money involved here, and we achieved it, because now we don't have annual registration with an annual fee. They pay lesser fees on a 3-year renewal period. That is, after 3 years, they come back and then they pay like 1,000, 1,500, depending on the number of employees. There are 3 types of payment, which ranges from 1,000 to 2,500 rupees, Mauritian rupees. So you see, it's a very insignificant amount of money. It's not a huge amount of money. So people can pay even, small, what we call your SMEs, small, medium enterprises. They can pay this amount depending on the number of employees that they have. So we thought it was very important to maintain that registration. And that was a major difference between the GDPR and the Data Protection Act of Mauritius. And there's nothing wrong in it. It doesn't, the GDPR also doesn't say that you need to actually not have registration. We just say you might not have registration in your Data Protection Act. So it's not a problem.
Wonderful. All right. So I would like to say, actually, there's a quick question that I would like for you to sum up this session with. The lessons you've learned so far, especially around some of the challenges the office has had, and the approaches you use to deal with them.
Well, challenges, we've been having challenges, I think, since we started the office, because privacy, as you know, even now today after the GDPR, is a topic that many people challenge by nature. So it's not something which is readily accepted. It's not like you have, let's say, banking laws and, financial laws, and people just abide to them, they don't question it. Whereas for privacy, we have to justify each and every enforcement activity that we do. And I can tell you, let's say we take 1 year on one case to be able to inquire, to get the cooperation of all parties, to get people to bring evidence, to go to justify why we need it. We actually go even up to the level of a Supreme Court to fight our principles, which at the international level we don't have. Let me give you one example. Just recently, we are having a case here, a very big case that we have inquired, where actually they are putting cameras in the cab cameras in lorries because they're carrying fuel and hazardous products. And I gave a decision saying that these cameras are actually invasive. They are privacy invasive. And the big company is telling us, they went to the tribunal, they are questioning my decision, and we have not had any jurisprudence on this issue, except one from Canada, which is not too privacy protective, and from Italy that we are relying on just to make sure that we are going to win this case. And I guess we will, because it is going in our favor. So I must tell you that this is a very complicated arena. It looks easy, but it's not. We have to fight a lot in terms of developing principles, developing practices to make sure that people respect them. Believe me, this is a big challenge that we've been having since we started the office. But as you know, if I can say it, that we have won 99.9% of all our cases before the tribunal. Those who have gone to the Supreme Court, they have withdrawn their cases before the Supreme Court because they cannot fight against the principles. Just to tell you that, yes, we are in the right direction. We are not bluffing. We are making sure that things are happening in the right way. So yes, it's a personal satisfaction as well.
Okay, well, it's a good thing to have personal satisfaction from what you're so passionate about. Judicial Madhub, thank you so much for gracing us with your presence and your insights for the Regulators Progress Dialogue.
My pleasure.